Hello, everyone, and welcome to Uncivil Law, where we learn through the misfortunes of others. As always, I'm your host, Uncivil Law, a licensed attorney in Texas, Virginia, and before the United States Supreme Court, and I hope you're having a great day. It's been a complicated tech day over here at Uncivil Law headquarters. It has just been one tech thing after another. Nothing was going to go right today, I suppose. So first thing that went wrong this morning is when I woke up, my computer monitor, which is also a TV, died. It's very sad. Technology does not last forever, and unfortunately the TV just didn't turn on today. Tried unplugging it and doing all things, changing the batteries in the remote, and so forth and so on. But no, it was not meant to be. The TV that is my computer monitor gave up the ghost. So I had to run out and buy a new one, which was annoying. And then the teleprompter software I wanted to use didn't really quite work. And the remote control that I bought to work with the thing isn't compatible. And then I had problems with the stream in YouTube. And then also I was having challenges with the camera placement and just other things. It was one of those days where just, nothing particularly bad, but it's just one of those days where one thing after another, little things go wrong. It's just one of those things, little things go wrong. It doesn't quite work. And you get frustrated and you're just a little bit upset, but it's okay. It's not that big a deal. We made on. On the plus side, it was interesting just seeing how cheap TVs have gotten in some ways. Because the TV I bought, it was a 43-inch 4K at Walmart. I bought it, I believe, a couple years ago for $398, and that was the cheap one. And today I bought a 4K 43-inch TV for like $230 or something. So it's just, price of technology drops, but it was just, interesting that's the way things go. So, hey, that's all right. So all is well in the world. No big problems over here at Castle Uncivil. And just trying to figure out things. Also, some people would ask me about my face in terms of the placement of how close I am to the camera and how big I am on camera. The reason that the way I look on camera is because of the monitor I have, right? So my camera has to sit above the monitor because the monitor is so tall, right? I've got a desk and then I got a 43-inch TV that's sitting on top of it, and the camera's got to sit above that. So the camera is sitting right above the monitor. So I can't really move the camera any further back, because if I move the camera further back, then the TV would be in the way, right? There's this physical object that's in the way. So the only other thing I could do, really, I could change the focal length of the lens, because I'm using a 30mm lens right now. I tried a 16mm lens, and that looked ridiculous. It looked absolutely absurd with that wide shot. Like, I was sitting exactly where I is, and it's like, it was so wide that looked like, it looked ridiculous. So it's 16mm lens. The reason, incidentally, so the only other thing I could do is put on my kit lens, and then I could change it because it has a zoom feature. But then I lose the sharpness of this nice piece of glass that I've had for a couple of years. So those are, and the aperture, because the kit lens does not have as low an aperture as this one does. Although right now the aperture is actually set at 3.3, so it probably wouldn't make a difference. So, yeah. Anyways, some of the challenges that we have. But let's get to our law stories. And then I've been looking at microphones, because I was thinking about maybe getting a new microphone, but the microphone I ordered arrived broke. It was physically broken. And so I had to send it back. And then I kind of decided I didn't want a new microphone after all. I like the microphone I have just fine. Challenges, my friend. Challenges. All right, let's talk about law. I see you in chat. You don't like the geek talk. Okay, I was just talking about my day. Let's talk about law. Alex Murdaugh's murder trial judge has stepped aside after Murdaugh's asked for a new trial in what was a very good decision by Judge Newman. The judge is simply too close on this particular one. He is too close to the situation. This case, of course, concerns whether or not the clerk of court improperly interfered with the jury due to her own book and also some affidavits from members of the jury who say the clerk of court improperly interfered with their deliberations and said things that they're not supposed to say. So there needs to be a hearing at this point. There needs to be a hearing. And the judge is also, Judge Newman is also potentially a witness for this hearing. So because he had conversations with the clerk and might have had other that are known, that are on the record, and might have had other communications with the clerk, nothing improper just because you're talking to someone because you're working with them all the time. Might have had other conversations with the clerk. So the judge is quite possibly a fact witness to whether or not this occurred, the behavior of the clerk, whether she was acting abnormal, whatever, right? So he's potentially a fact witness to this. Plus, he's just too close to the situation because it concerns whether or not something went wrong at a trial he was overseeing. So him being the judge in that hearing made no sense. So he has stepped aside, which, thank God, because it was the most only really viable thing to do. And I don't know, I think at this point we've got to have a hearing. And I think we've got to call some jurors to the stand and ask them what the hell went wrong, what the hell happened, and figure out whether or not there's a problem. I don't know whether or not there's a problem. I know that there's enough issues to ask. Yeah, and he hasn't stepped aside on financial crimes. That's true. But those crimes are, those cases are logically different. So there isn't necessarily a problem in that, but we'll discuss that as we go. Anyways, the judge that had presided over Alex Murdaugh's murder trial has agreed to step aside as the former lawyer who was convicted of killing his wife and young son requests a new trial, critically for our part, citing alleged jury tampering. The South Carolina Supreme Court said Thursday. So he decided to step aside voluntarily, or at least that's what the record reflects. Who made a call to whom, under what circumstances is unclear. So maybe the Supreme Court called the judge and be like, if you step aside voluntarily, then that would make our lives a lot easier. And so he stepped aside voluntarily. So the justices of the state Supreme Court dismissed basically the whole thing as moot, essentially. The justices refused a request to remove the judge from the state on financial crimes or to delay that trial because those are separate cases, right? If the issue is jury tampering, then the question is whether or not that particular jury was tainted, which wouldn't influence any other jury by its own terms, right? It's something that happened in that case or not. So if your issue is, this jury was tampered with, we'll go investigate that, but there's no reason to remove the judge from other proceedings because there's no allegations as to that proceedings at this time. Murdaugh, of course, at the moment is sentenced to life without parole. A jury had convicted him of 2 counts of murder in a somewhat weak case to my mind that, at least on first blush, I would characterize myself going into the jury room, were I a juror, I would characterize myself going into the jury room as a soft not guilty. I had some real problems with the timeline, and I had some real problems with how fast everything had to be. And also where the guns are and everything else. It required a lot of things to go right in what would have to be a very chaotic situation. And so I thought, and you're using the shotguns in very close range. You would think that, you'd be covered in blood or body parts or all the rest of it, and not just like a little speck of blood, somewhere. You would think there'd be a lot of it. Like, where did he wash himself off? How? There was no blood found in the drains of the house. There was no bloody clothes. The guns were never found. The whole thing seemed a little problematic. So I had some doubts that I would characterize as based on the reasons I just gave you just now. So I would be going into that jury room, if I were a juror, as a soft not guilty. I think I could be persuaded that he did it, but I have questions. And other members of the LawTube contingent have expressed stronger opinions. So I believe some of them have expressed very strong opinions that they don't think it was proven. Not quite that strong, but I think it is questionable whether he did it or not. Now, whether he knows who did it or whether he in some broad sense facilitated it, maybe, but he was literally accused of pulling the trigger, and I'm not sure he did that. But whatever. But he was convicted in any case. Months after his conviction, Murdaugh's lawyers request a new trial, saying several of the jurors, and I believe they have at least two, who they interviewed, told them County Clerk Court Rebecca Hill tampered with the jury by suggesting Murdaugh was guilty, encouraging the jurors not to deliberate a long time, and asking them about the case before deliberations. Also, apparently, at least according to one juror, threatening them that they couldn't have smoke breaks anymore, which could be a problem, for sure. As Alabama Rose noticed also, the trial also had problems because it focused so much on financial crimes. And that would have been another reason for the Court of Appeals to potentially reverse. Some of that was probably proper, but I think so much was brought in, it triggered a 403 problem under the rules of evidence. It was substantially more prejudicial than probative because of its accumulation and weight. And it became so much. It was a lot. So there was problems with the trial, to be sure. But the immediate problem is, of course, the jury tampering, because if that happened, then that is what we call structural error, and there's no amount of harmless error analysis at that point, right? Because normally sometimes you can do what's called a harmless error analysis and be like, well, there's so much evidence that he would have been convicted anyway, but this is structural error, right? And if that's true, you can't do a harmless error analysis because the structure was polluted, right? This isn't an evidentiary problem. This isn't a witness testified who shouldn't have. This isn't a piece of evidence that was brought in shouldn't have. Oh, there's so much other evidence. It wouldn't have mattered anyway. No, this is the jury was tampered with. So you can't fix that. You can't fix that with, oh, look at all the evidence. That's not how that works. Hill, for her part, of course, has denied the allegations. The defense wants a full hearing in which jurors and Hill can be put under oath and questioned and text messages and other information subpoenaed. I think they should get it. They have at least two jurors who say they saw things. There are things in the good clerk's book. There are also other things that seem problematic. Now, there's other jurors who say nothing went wrong. There is no problem, but, let's have a hearing. Let's put some jurors under oath. Let's ask them the question, figure out what's going on. As the trial judge, the judge would be the one typically to decide that request for a new trial because he would know the most facts. And so getting a new judge up to speed is not as ideal as using the same judge, but the defense wanted him removed because it is quite possible he needs to be a witness, which I think is fair because he was present to some of those conversations. Whether he's a necessary witness, I'm not sure, but it's possible. And so excluding him at this stage is the only thing that makes sense. The decision came a day before a pretrial hearing on the state charges that Murdaugh stole money from the clients. Newman will be on that bench for the hearing for now, and there's no reason not to. Because again, if the issue is the jury was tampered with, we've got a brand new jury that's hopefully untampered with, or at least if they are, that's something you have to prove in its own time. Murdaugh has also pled guilty to financial crimes in federal court and is awaiting sentencing that will likely mean years, if not decades, behind bars, regardless of what happens in the murders case, although it might influence where he serves his time. Because the typical rule is whoever gets to you first wins. That's the typical rule. Now, obviously, the sovereigns in their collective agreements can come to some other arrangement if they want. But the typical rule is whoever gets to you first wins. So South Carolina, in this case, got to Murdaugh first and sentenced him to time. And then the feds come along and we're going to sentence you to time too. Well, the Fed time in this situation would have come after the state time because the feds got there second. If the feds had got there first, they would have had their first crack. But now, if we overturn the murder conviction, right? Now suddenly the Fed case has primacy. He's already been convicted and sentenced on that. So it's quite possible he would serve his time in a federal prison rather than a state prison. And it is generally agreed that federal prison is slightly better than state. It is generally agreed that federal prison is better. So if you have to pick, the general consensus appears federal prison is the way to go. State prosecutors have said it's important that the trial, like the murder trial, be held in South Carolina because the victims want to hold them responsible. Murdaugh, of course, also faced state charges of insurance fraud after investigators said he asked a friend to kill him so his surviving son can get $10 million. For now, the state financial crimes trial is set to begin at the end of the month, where he is absolutely very guilty. He is incredibly guilty because, again, we heard all the evidence, or at least a sizable chunk of it, during the murder trial. So, we don't have to suspend judgment as much as we might in a normal case, where it's like, well, who can possibly say what will happen at trial? Well, we've already heard a pretty thorough preview of the financial crimes, and Murdaugh is super guilty, incredibly guilty of the financial crimes, incredibly guilty. To back off claims of jury tampering, they submitted responses of 18 different potential jurors to a questionnaire set up by the court. Most acknowledge they read stories, listened to podcasts, or watched documentaries about the case, which in and of itself isn't a problem, of course. Right? The only issue is that you have an open mind. So as long as you have an open mind, that the fact you saw pre-trial coverage isn't necessarily a problem. At a minimum, a jury for the new trial needs to be drawn from another county in the state, which quite possibly, right? So if we wind up doing this thing over, then we can go back to square one on all these sort of issues, because we're just going to do a do-over. And so one of the issues would be venue, right? Where should we have this thing? Now, normally the venue is, kind of, where the murder occurred, because that's normally how that works. Pin King says, can you serve both at the same time if the feds get to you first? Whether it's concurrent time or not depends. Concurrent is where you're serving at the same time. And that depends on a whole host of factors that I can't lay out in an easy way. So whether or not the Fed time is concurrent or not, whether or not you're doing both sentences at the same time or not, depends on a whole host of factors that I can't really speak to. But it's a good question. But it doesn't really matter, by the way, because Murdaugh's relatively old, and the financial crimes will keep him probably in federal prison until he dies anyway. So I'm not sure it really matters in this situation, but thank you for the $5 super chat. In any event, it is appreciated. Murdaugh is serving life without parole for the shooting deaths at the moment. It is not clear how long it'll take a new judge to get up to speed and rule on the request. Well, there's not much for the new judge to get up to speed on, to be honest, because, all things being equal, it'd be nice to have the same judge, but it isn't something that a new judge should have a problem with, right? I mean, you understand the base facts, you understand the base allegations, hold the hearing, figure out what's going on, and move on from there. So that's what's happening with all that. So all that good stuff. And that is the end of that story. So that is the end of Judge Newman's story. For the moment. And I'm glad he stepped down. I'm glad he stepped down because it's just something that he needs to take a little break from, because he's too close. Okay, is my browser going to work for me, or am I going to have further technical problems today? How deep do the problems go in Uncivil's life is the question today. Will the problems be big or the problems be small? Why can't Uncivil have nice things? All right, in the Crumbly trial, the parents have been given a separate trial, which implies that their defenses are to point the finger at each other. So you'll remember Ethan Crumbly, perhaps, as the shooter who went to school and shot up, his school. James and Jennifer Crumbly, the parents of that Ethan Crumbly, who of course has also already been sentenced, I believe, if memory serves correctly, in his own case, have been charged with manslaughter in what seems to me to be a incredibly questionable legal theory. And the Court of Appeal, this has already been up to the Court of Appeals on this issue. Like, can we charge him with this? And the Court of Appeals said yes. In what I thought was a magic trick kind of decision by the Court of Appeals. The Court of Appeals kind of hoping that you don't notice that they're pulling a fast one and doing a little misdirection and a little, hocus pocus. They're kind of hoping that you don't notice. because you read the decision as we have on stream, and you read between the lines as we have on stream. Can I swoop? I think I can swoop. Hold on. Sweet. Yeah, we got swoop. We got swoop action. Anyways, there's a conflict of interest and the attorneys are partners in the same firm. No, that wouldn't necessarily be the conflict of interest. No, that wouldn't be necessarily a conflict of interest in and of itself. Anyways, pressing on. The Court of Appeals decision was so weirdly written. And the Court of Appeals said something that struck me as completely impossible. Like, it's like, this is ridiculous, okay? So here's sort of the too long didn't read version of the story, okay? Here's what's going on, okay? Ethan Crumbly is having problems in school. He's having issues in education. He's having problems with his friends. He's not getting along with people. You know, he's having a somewhat classic teenage experience. Except for the shooting part, a lot of that sounds familiar from my own teenage years. You know, some problems in school. Things aren't necessarily going all great, all the rest of it, right? The parents buy him a pistol because they think, you know, maybe that will help him. It's something to show an interest in, and maybe it'll be something that he'll, you know, show interest in and all the rest of it. All right, so he goes to school, and while in class, he's writing this note / art / thing, which basically, like, you know, guns and death and all the rest of it, and, you know, kill, 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 and all the rest of it, right? So he's dragged to the principal's office. The parents come there. They powwow about for a while, and the school's like, you really should take your kid to a psychiatrist. Incidentally, they've already been trying to do that, by the way, up to this point, to varying degrees of success. They've had some problems finding a therapist, but they're like, sure. Can Ethan remain in school? The school's like, you bet. Sure, he can remain in school for the rest of the day. The gun he would use to kill them is already in his backpack. No one bothers to search it, right? And the parents don't bother to search it. The school doesn't bother to search it. He just goes back to class, takes his backpack with him, and then shoots up and kills 4 people. Okay. Now, what the Court of Appeals wrote, at least in part, in their infinite wisdom, was that a finder of fact, it is possible, a finder of fact, a reasonable jury could find, right? Because they have to find, essentially, that to find manslaughter, they have to essentially find that parents recklessly disregarded a substantial threat to other people's lives, okay? To keep it simple, all right? Ethan Crumbly, their child, was a ticking time bomb, and they just didn't care in some sort of blasé fashion. Now, how they're guilty and how the school's not guilty is beyond me, but let's press on, all right? So the Court of Appeals writes, in part, that not only is it possible a reasonable jury, a reasonably prudent jury, could find that the parents could have predicted that their son would shoot up the school, but more specifically, that a reasonable jury could find, based on the facts, that the parents could have predicted their son would shoot up the school that day. And that's where I sort of lost the plot, and I'm like, no. I'm sorry. That is just a lot of foresight. I mean, we want people to have foresight. Foresight is good. We don't want people to engage in inherently dangerous activities and, you know, not be like, well, I didn't know, right? It's like, if you just thought about it, you know, for half a second and used your brain parts, you would have been able to think about it. But I'm like, that's a lot of foresight. Not only is their son going to shoot up the school, which, you know, what reasonable parent would conclude that about their kid, but also, more specifically, that he was going to shoot up the school that particular day. And how the parents are supposed to be able to predict that, and not the parents, or not the school, is beyond me. So I have some, and then the Supreme Court of the state just decides not to hear the case. So I guess we're going to do this all over again on appeal on the same issues. Because I don't know how a reasonable jury is supposed to conclude that. That seems like that's asking a lot. That's asking for a lot of foresight, man. You know? Yeah. Okay. So anyway, James and Jennifer Crumbly, the parents of the shooter, who were each charged with involuntary manslaughter, have been given separate trials. Their son is to be sentenced less than a month away, so that's close. He hasn't been sentenced yet, but it's coming. The two will now proceed on separate fronts. Okay. The James's motion was made on November 13th. Jennifer also filed a motion to sever. On October 4th, the Michigan Supreme Court refused to hear appeals from James and Jennifer on the whole, does this case make any legal sense issue. Maybe they're hoping someone else will deal with the problem. The Court of Appeals seems to think there's enough evidence somehow, some way, that is beyond me. They had requested to attend their sentence hearing, and with the motion granted, it remains to be seen if the second defendant will have an advantage. Although we could, of course, have simultaneous trials, right? So we say the second defendant, but we could just go simultaneous. Get two sets of prosecutors in the room, two sets of defense lawyers in the room. Now you have separate trials, separate defense lawyers. So yeah, we could always do it simultaneously, back to back, one after the other. Yeah. So it doesn't say why they moved for separate trials, but the most logical reason that they moved for separate trials is that they're planning on pointing the finger at each other. Their defenses are mutually incompatible. That's the most logical. Their defenses are mutually incompatible. They're planning on pointing the finger at each other. So, yeah. So I guess all is not right in the Crumbly marriage either. Because otherwise, why would you grant the motion to sever? I mean, there are other reasons, but not many. And so, yeah, the most logical reason is that they're planning on pointing the finger at each other. So, good times. There are two new witnesses. How exciting. Is it possible for one of them to take the fall rather than finger point? Sure, but they could just do that by pleading guilty too. I mean, there's no reason to go to a trial for that. And they could do that now. So I don't know. Yeah. The most logical reason is they're planning on pointing the finger at each other. She was having an affair? That's good news. Oh. Let's see what else is going on. All right, this is a pretty interesting one from Mississippi dealing with advertising issues. In a federal lawsuit, owners of a medical marijuana dispensary say Mississippi is censoring business owners. Interesting. The owner of a Mississippi marijuana business, medical dispensary, filed a lawsuit challenging state regulations that say that he's not allowed to advertise. Okay. So, yeah, advertising when it comes to such things is tricky. And vices, advertising relating to beer, advertising relating to cigarettes. There's some stuff there. After Mississippi legalized medical marijuana to people with debilitating conditions, Clarence over here opened a shop, but he's been struggling to reach customers because the Mississippi Department of Health has banned medical marijuana for advertising in any media, which he says violates the First Amendment rights. Interesting for sure, right? Because you're dealing with this vices stuff, and I'd have to go back and start looking up case law dealing with advertisements relating to tobacco, advertisings relating to alcohol, what you can and can't do, how you can and can't advertise. There's a lot of case law dealing with that kind of stuff. So, yeah. But he's not allowed to advertise in any media at all, seems problematic. Like, even if he wasn't allowed to advertise in certain medias or say certain words or things like that, If he's not allowed to advertise at all, that seems legally problematic. So I'm not sure that Mississippi can go that far, but I'd have to check some of my older case law. He says, all I want to do, like any other business owner, is have the opportunity to advertise. If I pay taxes in the business, which I do, I should be able to advertise. All I'm asking for is the state to provide us with the same liberty they provide to other businesses. Also, adult clubs, incidentally, when it comes to advertising, signages, things like that. Adult shops. There's some case law out there dealing with some stuff, so you'd have to sort of get into that sort of domain and see what you're talking about. The individual who's represented by the Institute of Justice, who does fantastic work as an organization, great sort of libertarian related legal society, very good Institute of Justice. I've been to some of their conferences before. They do great work. Has sued the leaders of the state's Department of Health, Bureau of Revenue, and Alcohol Beverage. The lawsuit accuses state regulators of prohibiting business owners from engaging in truthful commercial speech to promote their legal business, which attorneys say violates the First Amendment. Okay. Under the ban, he can't advertise in any media. He can't place ads in newspapers or magazines, televisions or radios, or even billboards he already owns. The First Amendment does not allow a state to completely censor a legal business. If it's legal to sell the product, it's legal to talk about the product. That's probably true. A total ban is problematic. Yeah. A spokesperson for the Mississippi Department of Health did not immediately respond to an email, which they wouldn't. Arkansas, Louisiana, and Alabama also have regulations that prohibit dispensary from advertising through public mediums, but they argue Mississippi's regulations are even more stringent than those in neighboring states, which, yeah, the devil's very much going to be in the details when it comes to such things. Mississippi law allows patients to buy up to 3.6 grams of cannabis per day, up to 6 days every week. The State Department of Health cannot prevent dispensaries from placing signage on their property. All other advertising restrictions are up to the health department, which prohibits dispensaries from advertising and marketing in any media, including social media, I guess. So yeah, that seems like it's a little bit much. I don't think that much can stand, right? If, you can think about some regulations, time, place, manner, regulations with some of the vices stuff, but a total ban in all media, yeah, I don't think that can survive First Amendment analysis. The state's government cannot simultaneously authorize the legal sale of a product while forbidding truthful advertising. It's simply unfair to every other legal business in Mississippi is allowed to advertise while I have to rely on word of mouth. Fair enough. So yeah, I expect him to win if it's really that stringent, right? I think Mississippi can do some of these things, but they can't do all the things at once. All right, they might be able to do some of it in pieces, but they can't do everything. So that's something where you'd have to look up the case law. But if you have a ban that wide, I would think that would be problematic. So I would take that case. Because I'm like, yeah. It's like, I'm not sure which part of it's illegal, but some of it's got to be, right? So good times. I want to talk about George Santos. George Santos, the lying member of Congress. Wait, I have to narrow that down. The lying member of Congress from New York. No, still not specific enough. All right. This guy who significantly embezzled his resume and lied about all the things and is just a super liar for, forever and all in every possible way. George Santos has said he will not seek re-election after scathing ethics reports cite evidence of lawbreaking. They tried to expel him from the House. The Democrats voted for it. Some of the Republicans voted for it, but not enough, in my opinion. They should have expelled his ass. He's a travesty. Swoop? Okay. Lol. Lol. Hold on. Oh, let's see. Is it default? Okay. What happens if I do this? Still no sound for the bee fish. Oh, well. No, there's media source. I see it down there. Ah, yep, there it is. Ah, I see it. Ah, bee fish noise. Nice. All right. So George Santos over here, who somehow remains a member of the House somehow, says he will not seek re-election after a scathing ethics report cites evidence of lawbreaking. What happened to other bee fish? We have other bee fish that I have to like make a thing. How do I do that while not breaking everything simultaneously? That's a good question. Hold on. Can I split this into studio mode? What happens if I do that? Oh, yeah. What happens if I do this? Oh, yeah. Okay, hold on. So, wait. Okay. So I might be able to add in other bee fish. What did I do with other bee fish? Hold on. Let's see. Okay, source. Let's see. Media file. Add source. Add source. Properties. Okay, now I need to change that. What did I do with other bee fish? Let's see. What did I do with other bee fish? Hold on. Is it in logo? No, it's not there. What did I do with it? I lost it. Other bee fish is on mod chat. Hold on. Yep. Hold on. Oh, yeah. Yep. Yep. Okay. Good. Cut that. Put it here. Cut that. Put it here. Do this. Paste it here. Yeah. Now, if I change it to this. Nope, not there. If I change it to this. Yeah. Okay. Let's see. Close. Okay. Oh, yeah. Okay, people. We've achieved victory. We've achieved victory. All right. Bee fish number 2. Yeah. Yeah. All right. George Santos is not going to seek re-election. The House Ethics Committee, in a scathing report on Thursday, said it has amassed overwhelming evidence of lawbreaking by George Santos of New York that has been sent to the Justice Department. He's going to jail, by the way. He's totally going to jail. Yeah. Would I like to talk to Santos? I don't know, man. That'd be interesting. Shortly after the panel report was released, Santos blasted in a tweet on X only as a disguised political smear, but said he would not be seeking re-election to a second term. He gave, however, no indication that he would step aside, vowing to pursue his conservative values. The man does not have conservative values. He's a liar. He's even more of a liar than a normal politician. But a renewed effort to expel him from the House was quickly launched, so we might try to expel him again, which I'm here for that, by the way. The panel says Santos knowingly caused his campaign committee to file false or incomplete reports with the FEC, used campaign funds for personal purposes, and violated the Ethics in Government Act concerning financial disclosures filed with the House. Representative Santos sought to fraudulently exploit every aspect of his House candidacy for his own personal financial profit. Raj Shah, a spokesman for the House Speaker, said the report is very troubling. The statement stopped short of any specific recommendation about punishment. Before an earlier expulsion vote, Johnson said Santos was entitled to due process and voted no. I mean, strictly speaking, he's not entitled to due process. Expelling him is a political act. The House can do what it wants. They should, though. He should. As a member of both parties, members of Ethics Committee and Representative Santos returned to Congress. It's been a hot minute since we've expelled someone from Congress. It's been a while. Santos definitely deserves it. The report also detailed Santos's lack of cooperation with the investigation, saying he evaded straightforward requests for information. Particularly troubling was the lack of candor during the investigation itself. He'd go into jail. The panel tasked with the investigating the allegations against Santos provided him with a chance to submit a signed written statement, provide documents responsive to the request, and provide a statement under oath, but he didn't do that. The information he did provide, according to the committee, included material misrepresentations that further advanced falsehoods made in his campaign. He is a lying liar who lies, man. He is a lying liar. The committee's investigation panel said without Santos' cooperation, it was unable to verify whether some expenses were legitimate, but certain expenses on their face did not appear to have a campaign nexus. For example, it cited $2,000 spent at resorts in Atlantic City and $1,400 spent at a skin spa for what one spreadsheet described as Botox. Is Botox a legitimate campaign expense? I mean, you do have to look nice for the people. Is that a legitimate expense? I don't know. The panel also identified $3,000 expense from a hotel stay, though the campaign's calendar indicated he was off at the Hamptons for the weekend. There was tax and hotel charges on campaign credit card from Las Vegas during a time when Santos told his campaign staff he was on his honeymoon. Someone married this fool, man? Someone getting a divorce, I'm telling you what. The investigator also looked into at least $200,000 that was transferred to a Florida-based company, Redstone Strategies, to Santos's personal bank account. The report said at least 3 people transferred money to Redstone after being told the money would be used for political purposes, but the funds were transferred to Santos's personal accounts, which sounds suspiciously like a campaign finance violation. Santos used some of the money to pay down credit card bills, make a $4,000 permit purchase at Hermes, and smaller purchases at OnlyFans. Maybe he was just doing some constituent service. I mean, you got to reach out to your constituents wherever they can be found, and a little one-on-one constituent service to your constituents who are working the OnlyFans gig really shows that level of personal attention the voters crave. Am I right or am I right? I mean, what's the problem? Maybe you can get them to put Santos for president, like on their chest or something, and make it a campaign billboard. That'd be good. This committee determined Santos's conduct warrants public commendation, is beneath the dignity of the office, and has brought discredit upon the House. The congressman also faces 23 counts in federal indictment, alleging he stole the identities of campaign donors and used their credit cards to make tens of thousands of dollars in purchases. Yeah. It's pronounced Hermes. Well, la-di-da. I guess I don't shop at the right boutiques, man. I'm just giving you a hard time. Sorry, I'm not ritzy enough to know that's pronounced Hermes. Okay, Hermes. I'm sorry. The H is silent. Federal prosecutors say Santos has pled not guilty, wired some of the money to his personal bank account, and used the rest to pad his campaign coffers. Santos, who represents parts of Queen and Long Island, is also accused of FEC violations, saying he loaned his campaign $500,000 when he actually hadn't given anything and less than $8,000 in the bank. The fake loan apparently was an attempt to convince Republican Party officials that he was a serious candidate. Yeah. The Justice Department, of course, declined to comment because they never do, because they have class. Earlier this week, a former fundraiser for Santos pleaded guilty. Santos survived a vote to expel him earlier, but I wouldn't necessarily, bank. I'm not spending $4,000 at Hermes or anywhere. That's just too much. Representative Susan Wall, for example, the ranking Democrat on ethics, said she was no longer obligated to maintain neutrality because the committee's work is done. I intend to vote yes on a privilege expulsion. Representative Jeff Jackson of North Carolina, who voted against expelling Santos, said he's now received due process. So there seems to be some increased interest in possibly forcing him out. It's like, you're not going to seek re-election. We're not even going to give you the chance. Expel him, man. Expel him from the House. Do it. Do it now. Expulsion, the sternest form of punishment, has occurred just 5 times in the history of the House. 3 times during the Civil War for disloyalty, and twice after convictions on federal charges, most recently in 2002. So we haven't done it that often, but he needs it. So if Santos were to be expelled, it would narrow the GOP's thin majority, but that's fine. While Santos said he won't seek re-election, his campaign is already woefully short on resources, and yeah, it's not going well for him. So he's going down. He's going down. He's going to prison. He should see if he could get a condel to Hong Kong and just stay there or something. Maybe that'll go well for him. Yeah, $4,000 for like a single item of anything seems pretty expensive if it's clothing or clothing adjacent. I'm just saying, This shirt, I think, cost about $5. It's comfortable and it clothes me. Mission accomplished. All right, Starbucks. For people asking about Starbucks. Well, Starbucks is having further problems in a beleaguered company, having more problems. Workers at more than 200 Starbucks locations walked off the job on Thursday in what organizers said was the largest strike yet in the two-year-old effort to unionize the company stores. The Worker United Union chose Starbucks' annual Red Cup Day to stage the walkout, since it's usually one of the biggest days of the year. Starbucks expects to give away thousands of cups to customers who order holiday drinks. Yeah. Yeah. No, I mean, the shirt. Look, I'm wearing a nice shirt. I got on, regular underwear you get at Walmart. My jeans are, just regular jeans you get, For $4,000, you could easily buy my entire wardrobe. Yeah. The union said it was expecting more than 5,000 workers to take part in the Red Cup Rebellion. Just make my coffee, please. Although I make my own coffee, thank you very much. Right now I'm using HEB's creme brulee blend, which I'm quite liking, to be honest. It's very sweet. Very nice coffee. I make it myself. It's glorious. My coffee machine never says no. Juniper Schweitzer, who has worked for Starbucks for 16 years. Juniper Schweitzer might be the most Starbucks name I've ever read in my life. What color do you think Juniper Schweitzer's hair is? Says she loves the company and its ideals, believes it's not living up to them. They promised us the world and have not delivered. They promised you a job and they've been paying you. Frequent promotions like Red Cup Day or buy one, get one free offers put added stress on workers who say they have no ability to switch off mobile orders, otherwise control the workflow. Well, no, because no. I mean, you can imagine Starbucks orders: decaf, grande, non-fat, 3.5 Splenda mocha with no whip. Multiply that by 100 and you just get drink. We just have a basically infinite amount of drinks and we're understaffed and we're underpaid and we're sick of it. You could quit. Pampered Shelly gets $1.99. It says HEB has all the food flavors. They certainly do. HEB is a great grocery store. Edwin Palmosis, a Starbucks employee for more than 2 years, joined the picket line Thursday in front of his New York store. His store voted to unionize last year, but so far Starbucks and the union haven't started bargaining. He thinks the contract wouldn't help improve working conditions at the busy store. It's been more of a downgrade than uphill for us. It's been exhausting trying to deal with their retaliation, and not much change in the past year. Thursday's strike was the 5th major labor action by Starbucks workers since the store in Buffalo, New York became the first unionized in late 2021. Workers at more than 110 stores walked out last year on Red Cup Day. Most recently, a strike in June protested reports that Starbucks had removed pride displays from stores. You know, if you come over to my place, I will make you coffee and I'll even put it in a red cup for you if you like. Kurt Bucks, the best coffee in town. Only in Texas, baby. The strikes so far have had little financial impact on Starbucks. Starbucks apparently had 12% increase in revenue. Starbucks says Thursday many of its stores with striking workers remained open, staffed by supervisors, managers, and employees who chose not to strike or visit from nearby stores to pick up additional hours. We have nearly 10,000 stores opening right now, delighting our customers with the joy of Red Cup Day. Yeah. At least 363. We could also have bourbon. I could make you a martini. I could make you a margarita. I could make you some lemonade vodka or something. Got some Guinness in the fridge. I got some wine. I'm a good host. At least 363 company-operated Starbucks stores in 41 states have voted to unionize since 2021. The Starbucks effort was at the leading edge of a period of labor activism that also seen strikes by Amazon workers, auto workers, and Hollywood writers and actors. At least 457,000 workers have participated in 315 strikes in the U.S. just this last year. Yeah. Starbucks opposes the unionization effort and has yet to reach a labor agreement with any of the stores that voted to unionize. The process has been contentious. Regional offices with the National Labor Relations Board have issued 111 complaints against Starbucks for unfair labor practices, including refusal to bargain. Starbucks says Workers United is refusing to schedule bargaining sessions. Starbucks noted that it started bargaining with the Teamsters Union, which organized a Starbucks store outside of Pittsburgh in 2022. But the two sides have not reached an agreement. An employee answering the phone at the store Thursday said it wasn't participating in the strike. Bailey's and eggnog? That sounds nice. Relationship between Starbucks and Workers United have grown increasingly tense. Last month, Starbucks sued Workers United, saying a pro-Palestinian post on a union account damaged its reputation, demanding the union stop using the Starbucks name. But on Thursday, most strikers were focused on work issues and pay. Mooney Atchley, who works as a mixologist at a Starbucks store. What the fuck is a mixologist at a Starbucks store? Was picketing outside a non-union store where the first Starbucks opened in 1971. Ashley says she often struggles to pay her rent and buy food on her Starbucks paycheck, even though she lives outside the city. The union is fighting for a better Starbucks. We want the best for the company. Yeah, sure you do. I think the company wants what's best for the company. Yeah. Michelle says, if I was 10 years younger, I'd still be too old for you. I appreciate that. I'm getting older, my friends. I'm getting older, and it's kind of sad. I went to my alma mater when I was visiting my parents. I went to Clemson just to poke around and see what's changed, and the answer was a lot. Across from Bowman Field, there used to be a place called Clemson House where I stayed. It sort of looked like a hotel, but it was a housing unit. And I stayed there, and then a couple years after I graduated, they blew it up. And then they did some construction. And so all up on that like hill up across from Bowman, there's a new College of Business over there. There's a Starbucks there. There's housing up there. There's parking lots up there. Like so much, like all this stuff is there that didn't used to be. Like none of this stuff was there when I went to school. And it was kind of sad. And I don't know if I'm the only person that has this issue. But when intentionally they demolished it. It was intentional. I don't know if I'm the only one who has this issue. But when I imagine myself in the past, I imagine myself as I look now. Like I don't really remember myself in the past looking differently than I do now. And so when I went to Clemson and I'm around all these college students, I'm like, I'm too old for this crowd. This crowd, I'm too old for this crowd. Some of these people could literally be my children. And it was a very interesting experience. It was literally, you can't go home again. But it was an interesting things. No, not the murder house. That was a different house. They blew up Clemson House. It was a dorm on campus. The murder house, I don't know if it's still there or not. It wouldn't surprise me. Also, no one got murdered in the murder house. That was at a different location. Yeah. I lived with a murderer. Okay? I lived with a murderer. But that wasn't on campus. That wasn't campus housing. That was off-campus housing when I was in law school. This is undergrad. All right. He wasn't a murderer when I started living there. All right. This is just fun. This probably won't go anywhere, but I thought this was fun. Yeah. All right. QAnon shaman is planning on running for Congress as a libertarian candidate, which is just hilarious. One of my roommates in my first year of law school murdered his father. It happens to everybody, right? Jacob Chansley, the spear-carrying rider who was horned, fur hat, bare chest, and face paint, made him one of the more recognizable figures on the attack on the Capitol, apparently aspires to become a member of Congress, which I think is hilarious. The 35-year-old is filed as a candidate, indicating he wants to run as a libertarian for Arizona's 8th congressional seat. I'll give him a couple bucks. U.S. Rep. Debbie Lesko, the 64-year-old Republican representing the district, announced last month she won't seek re-election. Chansley had pled guilty to felony charge of obstructing a proceeding at Congress. He was sentenced to 41 months in prison and served about 27 months before being transferred to a halfway house in March. And then, some evidence came out that suggested that maybe things weren't necessarily what they appeared, and he was basically let go. Chansley is among more than 700 people who were sentenced in relation to the Capitol riots. Authorities say Chansley was among the first rioters to enter the building and acknowledged using the bullhorn to rouse the mob. Although previously calling himself QAnon shaman, he has apparently since disavowed QAnon. All right, that's good. That's good for that. He identifies himself as Jacob Angeli Chansley in the candidate statement of interest work filed with the Arizona Secretary of State's office. The U.S. Constitution does not prohibit felons from holding office, but Arizona law prohibits felons from voting until they've completed their sentence. So he can't vote for himself, but he can run. I'll donate a couple bucks to his campaign. Should be fun. So that is QAnon shaman is running for Congress. I'd vote for him. Because that just seems fun. We'll let you into the building through the front door. All right, let's see what else we got going on today. What is this? An airplane took off without its windows. Okay, that doesn't normally happen. A U.S.-bound plane from London took off with missing and damaged window panes, which seems like the kind of thing that someone would notice on the pre-flight inspection, but apparently not. Here are the windows, and yeah, there seems to be a problem there. Did no one notice that? Apparently no one noticed that. Apparently no one noticed that the window panes were just, missing from the plane. And we're going to fly international. We're going to fly over the ocean. That's not an issue in any way. Okay. That pre-flight inspection not looking great. An aircraft bound for the United States took flight with missing and damaged window panes. According to the bulletin, which was issued Friday, several cabin windows on the Airbus were damaged by high-power lights used during a filming event. But the damage wasn't discovered until after the aircraft's next flight was already in the air. The bulletin noted that more severe consequences could have arisen if window integrity was lost at a higher differential pressure. You think? The flight took off from London's Stansted Airport and was set to land in Orlando. It was carrying a crew of 11 and 9 passengers. Not many people on this plane. After takeoff, passengers reported that the cabin seemed colder and noisier than it normally would have, but it wasn't until an air crew member walked around the back and agreed it was loud enough to damage your hearing the crew realized something was wrong. The special bulletin said the crew member's attention was drawn to a cabin window on the left side of the plane and observed that the window seal was flapping in the airflow and the window pane appeared to have slipped down. The crew member informed others of the missing window, which was discovered when the plane had already climbed to 14,500 feet. The bulletin said pilots reduced flight speed and stopped climbing as the engineer and a third pilot went to check it out. Based on their observations, the crew decided to return to the airport. The plane landed normally at the airport and the plane remained pressurized normally throughout the flight. Well, that's exciting. Once the plane was parked, the crew inspected and found that 2 window panes were missing. A third window pane was dislodged and a fourth protruded from the left side of the plane. Investigators determined the panes faced thermal damage after being exposed to intense lighting for 4 to 5 hours the day before. Maxi Bright's 12 lights were used to simulate a sunrise from inside the aircraft for an unspecified filming the day before. The lights are supposed to be shined at a distance of 10 meters, but they are placed anywhere from 6 to 9 meters while they illuminate the plane. So literally the light itself was so hot. The light was so bright and so hot, it warped the plane. That's just great decision making there on every possible way. That is just fantastic. That is just absolutely wonderful, grand news. So no one, yeah, the plane seems a little bit colder, seems a little bit louder than normal. Let's see what else is going on. Another flight mishap. How about another flight mishap? How about B-Fish? Yeah. A horse loose on a flight to Belgium forces a cargo jet back to New York. A horse. A horse got loose on the plane. There are some sentences you don't normally see strung together. What was the problem on the plane? The horse. Okay. A cargo jet headed towards Belgium from New York had to turn around mid-flight after a horse escaped its stall and got loose in the hold. The Boeing 747, operated by Air Atlantic Iceland, had just started its flight across the Atlantic Ocean when pilot radioed air traffic control in Boston and said a horse on board had escaped its stall. We don't have a problem as of flying wise, but we need to return back to New York. We can't get the horse back secured. The controller cleared the aircraft to land at John F. Kennedy. The pilot said due to the plane's weight, he had to dump 20 tons of fuel before going back to New York. The controller gave the okay and alerted nearby pilots about a fuel dumping in progress, approximately 10 miles west of Martha's Vineyard. The 747 pilot had one more request. I do believe we need a veterinarian, I guess you call it, for horse upon landing. Is that something you can speak to New York? Emergency vet to show up at the... The controller said they would pass it on. But there was apparently no comment. That's sad. Okay. That's a good one. That's pretty funny. And to round out the flying news, good news, people. There is a new option for a flying car. Now, there have been cars that take off before, will transform into a plane. But this one is different because this does vertical takeoff. So it's a helicopter plane car. You don't need a runway. It's a drone that you can drive, fly, and hover in. How exciting. Your drone plane helicopter hover car is apparently available for $190,000. I think I'm going to wait until, the third or fourth model year on that one. Just between you and me. The new electric vertical takeoff and landing vehicle apparently does not require a pilot's license somehow. The plane car helicopter is a single seater vertical takeoff that's shaped like a sideways H. The pilot sits in the middle part of the H with a fixed wing in front of them and one behind them. 4 propellers, that would be your propellers on your drone, big ass drone, provide lift and propulsion. The car plane helicopter has a top speed of 62 and a range of about 20 miles. Better watch that fuel gauge real close. Depending on the model, it can take from 75 minutes to 4.5 hours to charge. And also, it can't actually drive on the ground. So, not so much a car then. But you can fly for 20 minutes. You better make sure that you're on the ground at 1959 or you're going to have a bad time. I do not recommend buying this in every possible way. This seems like an exceptionally bad idea. This seems like a horror show waiting to happen. Please do not buy this car, helicopter, plane. I beg of you. This is a product liability nightmare waiting to happen, I'm pretty sure. The first vehicles will start shipping apparently 2024. That's good news. While operators apparently don't need a pilot's license to fly the thing, they do have to undergo 1 to 2 weeks of training. After that, they'll be cleared to fly only during daylight hours in Class G airspace over uncongested areas. If you buy this thing, you have a death wish. Yeah, let me buy the first generation electric hover thing from a company I've never heard of and has a 20-minute fly time. That sounds like something I want to risk my life on. Apparently not content to kill only one person at a time, the company is also set to develop 2- and 4-seaters. So you can kill your entire family. How exciting. Do not buy this. Do not buy this. You're going to get a Bluetooth over-the-air update. The plane car is going to be like updating, and then things going to fall out of the sky. Dude, no. Yeah, don't do that. No, yeah, no. Without a pilot's license, how would I know what Class G airspace is? Apparently, you get that information during the week training. So I guess that will solve that problem. Do not buy this plane car. Do not buy the first generation of this plane air car. Don't buy it for at least 5 years. Bare minimum. Let other people be the cautionary tale. I'm just telling you. I'm just telling you. That is my official legal and engineering advice for the day. All right. For our last story today, we're going to do a deep dive story. And I guess we'll probably segment this out from the live and release it separately. So, hey, it's a twofer. So for those of you who are here live, you get to watch it. And for those of you not live, I guess you get to watch it again. Because, hey, why not post it twice? Name one insurance company that will cover that. Lloyd's of London will cover anything if you pay them enough money. So Lloyd's of London is always a good one. All right, we're going to spend a little bit of time. For today's story, we're going to spend a little bit of time dealing with this motion from the Church of Scientology in relation to the ongoing lawsuit from Leah Remini. You may remember this lawsuit. We covered the complaint, and now we're going to deal with the anti-slap motion, which we all knew was coming, of course. I have some doubts regarding the complaint. We've covered those doubts. I have some issues, most of which being, it seemed like a lot of leaps of logic to my mind. If there was a problem, at least to my mind, in Remini's complaint with really tying it to Scientology, and to the extent they could, it seemed a little outdated and not necessarily to the facts in question. So there were a lot of questions in my mind, but we'll cover this for the anti-slap and see what the Church of Scientology has to bring it. So let's go ahead and do that. All right. All right, so it's table of contents. All right, let's read some of this and see where we're sitting. After being expelled from the Church of Scientology over a decade ago for unethical conduct, plaintiff Leah Remini has made a lucrative career spewing hate and inspiring violence against the Church of Scientology. That's also very factually disputable for very similar reasons. Just because Leah Remini says things doesn't mean she's responsible for violence that occurs. So same causation problems the other way, incidentally. Its parishioners and the ecclesiastical leader of the Scientology religion. She has done this through her autobiography, a cable television show, podcasts, and appearances on broadcast and radio. She has used these platforms to call the church pure effing evil, and its parishioners sick assholes, fucking like body snatchers, and morally depleted, aiming to falsely accuse the ecclesiastical leader of the religion of unidentified crimes. Plaintiff candidly admits that she spends hate for cash, boasting to ABC News, "I don't work for free." She admits her anti-Scientology TV show, supposedly investigative journalism, was a sham. "Listen, that's how it works, honey doll. That's how you do it. It's not reality. I plan all these episodes, and we figure it out beforehand on who's going to say what." Yeah. Yet the harm and terror she's caused is all too real. Okay, settle down, Scientology, settle down. Since plaintiff started her hate campaign, the Church of Scientology, its ecclesiastical leader, clergy, and parishioners have endured more than 500 acts of hate, vandalism, incidents of harassment, and threats of violence and death. And you can't put this on Leah's shoulders because she's not responsible for that, for similar reasons. Like, just because she has an opinion and is expressing it isn't enough, right? It's like, you need something a little bit more. Within an hour of debut of the second season of the TV show, the church received threats. "You're all dead. I'm going to murder you all, you pig cult bastards, and blow up all your buildings. You're all effed. All the churches are going to be gone. Every asshole Scientologist dead. People say shit. News at 11. Refusing to remain silent in the face of threats and violence plaintiff inspired, the church fought back. It shined a light on plaintiff's ugliness, showing the world the degrading comments plaintiff has made about Scientologists and their ecclesiastical leader." Just because you keep saying ecclesiastical doesn't make it true, by the way, guys. I'm just saying. It lets her supporters know that they were giving comfort to an anti-religious bigot. It detailed the hundreds of threats and crimes inspired by plaintiff's speech. And it did this all to commit to principal alien to plaintiff. The church always told the truth. Okay. Everything the church has said about plaintiff's hate and bigotry is documented, most out of the mouth of plaintiff herself. Now she's on the receiving end of the speech. Well, it's not just speech, incidentally, that she's suing for. But there is a causation problem. So the church might very well be right on the anti-SLAPP, right? Just because, it's just because the church says stuff isn't enough, right? The church says stuff, and people are responsible for their own conduct. Right. So I tend to look at these kinds of claims both ways with a bit of skepticism. Right. If I say things like, if I just simply said, like, I don't like creator so-and-so, right? Me merely saying that is not the same thing as me saying, what I want from you, members of the chat, is go into creator so-and-so's chat and do XYZ, right? It's not a command, right? Me expressing an opinion, even a strong opinion, is not the same thing as me commanding something, right? So I take a view where it's like, I want more than, simply expressions of dislike, or I want more of simply expressions of, whatever, I simply want more than teachings, for just to put it another way, right? Is the Christian church responsible for or any given Christian church for that matter, is the First Baptist Church of Wichita, or whatever, responsible if one of its parishioners, in the name of Christ, goes and does some shit? Not unless the First Baptist Church of Wichita is commanding the shit, right? Just because they make some teachings, and just because they have some ideas, people are responsible for their own bullshit. So, Leah is not responsible because people express mean opinions to the Church of Scientology. Right? Unless she commands it, unless she directs it, she inspires it, whatever the bullshit that means, right? That is not enough, right? And so for very similar reasons to that, when it comes to the Church of Scientology themselves, I'm going to want a little bit more, right? I'm going to want a little bit more than they teach these things, because people are responsible for their own shit. As a general proposition, I'm not saying you can't get there. I'm not saying it's impossible. I am saying that in Leah's initial complaint, I, for one, found it a little bit wanting. I found it a little bit like, here's some stuff the Church of Scientology has said, and here's some preachings they've done, and here's some things that we think members of the Church of Scientology have done. Even that they're a little unclear about, because they don't know for sure these people are the Church of Scientology, it seems. And even if they knew that, it's still like the causal connection is a want to be desired. So, so I'm a little bit skeptical for those reasons. All right. Plaintiff has filed this complaint and attended application for preliminary injunction to stifle all dissent. This lawsuit is nothing but an attempt by plaintiff to stop defendant Church of Scientology and Religious Technology Center from responding to her hateful attacks with truthful speech. Each cause of action she alleges seeks to impose liability on defendants for stating opinions about a plaintiff's hateful conduct, such as she is a bigot, which is a statement of opinion, or of uncontrovertible truth, such as plaintiff defended and continues to defend a man found liable for sexual assault. Indeed, in her complaint, plaintiff has not identified a single statement by the church that is neither opinion nor true. I found similar problems in her complaint, to be quite honest. Yeah. Plaintiff's attempt to tortify. I'm not sure I've actually seen the word tort change in that form. That might be a new one. Tortify. Okay. Plaintiff's attempt to tortify a public debate that she initiated and profited from is why California enacted its anti-SLAPP statute. It's no surprise that the allegations satisfy both the fourth and second prong of an anti-SLAPP analysis. Plaintiff cannot deny under prong one that the statements at issue concern a matter of public interest. Making them so has been her bread and butter for decades. Okay. Alleged non-speech conduct the plaintiff characterizes surveillance is pre-litigation petitioning, and thus also protected prong one conduct. I don't know about that. That doesn't make sense. As to prong 2, whether the plaintiff can prevail on her claims, dozens of the allegations are barred by the applicable statute of limitations. And as to those that are not, they're non-actionable expressions of free speech, such as true statements, statements of opinion, and group boycott. In addition, plaintiff cannot meet her burden to establish through admissible evidence elements to each of her claims as she must to survive the motion. The length of the complaint belittles how little is actually there. When stripped of the allegations that depend on non-actionable statements, protected petitioning, or outside the statute of limitations, there's virtually nothing left. The Church of Scientology has some points. All right, we'll skip the factual background because, we'll just skip that because we've covered a lot of that before. And get to the legal analysis. All right, let's just get to the legal analysis. Legal standards and for anti-SLAPP, we understand that. Okay, the anti-SLAPP analysis has 2 steps. First, the moving party must show the challenged claim arises from an activity that's protected. If the moving party meets its burden, the burden shifts to plaintiffs to demonstrate the merit by establishing a probability of success. Okay. Remedy incorporates the protected allegations to all 9 of her causes of action. As one does, that's very typical. The charging allegations for each of these causes of allegations expressly incorporate all prior factual allegations, necessitating including the protected conduct discussed above. Okay. Plaintiff cannot show a probability prevailing on the merits of any claim based on protected activity. Okay. Therefore, all the identity allegations must be stricken. As a result, the 4th through 9th causes of action must be stricken in their entirety. Well, let's read them one at a time. The defendants satisfy prong 1 of the anti-SLAPP. The challenge allegations constitute speech and or petitioning activity protected under the statute. All right. Plaintiff alleges that defendant posted on the internet, either through the website operated by Stand or on Twitter, alleged defamatory statements about plaintiff's hate campaign against the church and violence that it caused. These internet postings meet one of the express statutory definitions of protected speech. Any written or oral statement or writing made in a place open to the public or in a public forum in connection with an interest of public interest. As with the alleged postings here, websites available to public or public forums, that's fine. More so, an issue of public interest means any issue in which the public is interested. That's fine. I think showing these are matters of public interest is fine. Determining whether the speech was made in connection with an interest of public interest calls for a 2-step analysis rooted in the statute's purpose and internal logic. First, we ask what the public issue is the speech in the question implicates, a question we answer by looking to the speech. Second, we ask what the functional relationship between the speech and the public conversation is. Here, the speech in question implicates Scientology and plaintiff's deliberate year-long attempt to vilify Scientology in the public eye. Those are patently issues of public interest. I agree. Further, by her own admission, plaintiff is also a matter of public interest. She describes herself as a public figure. She is. As an admitted celebrity and public figure, those factors alone qualify the church's statements about her as protected speech. In the first instance, maybe. Thank you, Sandy, for 10 gift memberships. That's very nice. We appreciate everyone who donates to the channel financially. Thank you. She discusses her Scientology-centric media history at length. She boasts about winning an Emmy for a speech that the church correctly labeled as hate speech, which incidentally is a meaningless term, so sure, and is now suing the church for response. There's no such thing as hate speech, so sure, it's hate speech because nothing's hate speech. It has no definition, so sure, why not? Let me zoom this in a little bit more. Furthermore, the context of the events shows the speech at issue and the public conversation about the matter of public interest not only have a functional relationship, but are one and the same. The above statements of fact show Plan for years has used every channel of international media. Thank you, Ann Bell Feinstein, for 5 gift memberships. I appreciate it. B Fish says thank you. Thank you. Okay. The above statement of fact shows the plan for years has used every channel of international media to spread hate about the church. The speech at issue here is the church's response to the plaintiff's unceasing attacks by pointing out plaintiff's lies, hypocrisy, immorality, and immense harm to innocent people she continues to cause. Indeed, many posts plaintiff's challenge address the repercussions of her own public statements or opine about those statements. This case presents a perfect storm of the issue of public interest. I don't know about that, but okay. Plaintiff complains defendants' alleged communications with media outlets and corporate sponsors urged them to refrain from doing business with her, given her bigoted hate speech. This is protected speech. I think it is too. Advocating that media companies and advertisers boycott or shun plaintiff's bigotry business is perhaps a classic example. Yeah, a boycott is not tortious. Yeah, a boycott is not tortious. Right? It's only tortious if you're lying, but generally, like, don't do business with them is not tortious. Even private communications such as phone calls, texts, and emails qualify for anti-SLAPP if those private communications further the public discourse. Okay, I'm for that. As in the prior case law, the speech they complain of in this case addresses a matter of public concern. A sitcom stars public vendetta against a worldwide religion. And the communications, be they texts, calls, emails, or letters, were directed at individuals with a direct connection to an authority over the public opinion of defendants. These were persons who aired a TV show about defendants, published video about defendants, hoisted podcasts about defendants, or sponsored shows. Okay. Petitioning in relation to surveillance. All right, this one I'm skeptical about, so sell me. Sell me, Church of Scientology. We'll see. Plaintiff, a celebrity who courts paparazzi, alleged defendants surveilled her in public. Public observation or surveillance is not self-tortious. That's true. It's not. Right? There's a difference between stalking and surveilling. Right? Private eyes surveil. And what you do in public, there's no reasonable expectation of privacy in public. So, yeah, that's fair enough. Plaintiff also states defendants' alleged surveillance was conducted by and through counsel. Furthermore, the plaintiff acknowledges the church publicized through its website that she filed a false police report and attempted to extort Scientology. As the website showed, plaintiff's false report regarding the wife of the ecclesiastical leader of the religion and plaintiff's extortionate threats to sue the church date back from 2013. She is definitely not a fan of you guys, that's for sure. Thus, from 2013 onward, before any of the alleged surveillance, plaintiff was threatening the church with legal action. The church was in a pre-litigation stance. I don't know. That seems too attenuated to me, but okay. This qualifies as pre-litigation investigation connection with the person's right of petition. I don't know about that one. They cite a case that says the use of surveillance by a private investigator to investigate potential conflicts of interest of a public official is protected First Amendment conduct. I don't think that quite works here as protected conduct. I appreciate the try, but I don't think it quite works. All right. Each of the causes of actions arises from the conduct. They demonstrate each cause directly stems from and is related to the activity. Every cause of action incorporates and re-alleges all the allegations, which of course it does. So, all right. Yeah. So I think the church is probably right, and I sort of expressed this already, right? It's like a lot of these statements, are colorably true, if aggressive. Their opinion, the surveillance to the extent it occurred, is not, you can kind of observe anyone going about their life in public. There's no reasonable expectation of privacy in public. So, it's not enough to say, okay, like if they're harassing you at home or something, but yeah. So I don't know. And Kurt just has to mention sitcom star. It's in the text. I believe I read it correctly, didn't I? I'm just reading what they wrote. Yeah, I think the Church of Scientology called her a sitcom star. So I'm just reciting it because it's there. So why are you mad at me? I'm just trying to recite this and analyze it. Because defendants satisfy prong one, plaintiff is required to establish a probability prevailing on any claim of relief. Whereas here, the cause of actions are mixed between protected activity and unprotected activity, plaintiffs must satisfy the burden by showing the allegations of protected conduct alone support particular claims for relief. Okay. When relief is sought based on allegations of both protected and unprotected activity, the unprotected activity is disregarded. That seems odd. When the second step is reached, the burden shifts to plaintiff. For the purposes of the immediate analysis, I guess that makes sense. The court must strike all the challenge allegations and causes of action 4 through 9 because plaintiff cannot establish a probability of success on specific claims for relief when they depend on protected speech and activity. To overcome the motion, plaintiff must demonstrate the complaint is both legally sufficient and supported by prima facie evidence. Plaintiff cannot rely on her pleading and instead must make the case with competent and admissible evidence. The second step is a summary judgment-like procedure. To demonstrate probability prevailing on the second prong, plaintiff is required to produce admissible evidence from which a trier of fact could find in his favor as to every element needed to be proven. Okay. Plaintiff's 6th, 7th, and 8th causes of actions assert the defendant published false and defamatory statements. The challenge statements are barred by the limitation, true statements of fact, non-actionable, and not published. If a claim depends on protected speech that occurs outside statute of limitations, that claim fails under the second prong. There's a 1-year statute of limitations for defamation-based speech claims within 6th, 7th, and 8th causes of action. On the face of the complaint, these statements concern speech that occurred more than 1 year before August 2nd, 2023. The claims based on protected speech in these paragraphs fail in the second prong for reasons stated in other parts of the complaint. Okay, that makes sense. Having spent years calling for the destruction of the church and demonizing Scientologists as traffickers, plaintiff now sues defendant for expressing negative opinions on her views and what they say about her character. The statements all amount to a subjective judgment rather than provably false statement of fact, and are not actionable. Courts have held that someone calling someone a racist or Nazi or invoking comparisons to KK are statements of opinion. That's the general consensus, yes. That's the general consensus. Neither plaintiff's hurt feeling nor any ill will defendants understandably bear towards her matter towards the analysis. Plaintiff incorporates by reference in her defamation claims these statements of non-actual opinion, statements that are non-provably false statements of fact, an untrustworthy apostate, a racist. She won her name in the news, has no morals. The National Enquirer is more credible than Miss Remini's documentary series. Nice. Incited bigotry. Plaintiff Scientology took credit for cancellation of her television show. She's speaking out against Scientology for the fame, money, and attention. Comparing Miss Remini and A&E Network to the Ku Klux Klan. Asking questions, are Leah Remini and A&E responsible for the wave of violence against Jehovah's Witnesses' Kingdoms Halls? A disgrace to women of valor everywhere. Bigot Leah Remini inspires praise of Hitler. That's a little much, but okay. I don't even know what that means. A&E and Leah Remini spread hate. And Leah Remini, the Dr. Jekyll and Mr. Hyde of Miss Hyde of Hollywood. Demonizing hateful content, promoting hate, sponsoring hate, an unhinged religious bigot who profits by spreading hate. What's next? A game show hosted by a KKK leader, neo-Nazi Jeopardy? That's just funny. And I wish I were a man so I could R-word too. Yeah. Rape apologist. Engages in obscenity-laced and abusive language to insult, defame, and demean Scientology. A vicious, lying, narcissistic, deranged, demented, and dangerous bigot. The Church of Scientology has strong opinions. But then again, in fairness, so does Leia. They are not strong fans of each other. They are both using some fairly strong words towards each other. So, the Church of Scientology does have a point. They do have a point. It's like, look, you say some shit about us, and we say some shit about you. We're trash talking each other a little bit, and now you're bitching about it. And also, like, they have a fair point that a fair amount of this is opinion, or yeah, it's like, or just completely non-actionable. It's so vague as to mean nothing. What does it mean to promote hate? What does it mean to sponsor hate? What does that mean? You know? So, yeah. Clearly didn't read Mein Kampf. Yeah. The plaintiff is abusive in the workplace and they should move to Russia, syndicating a hate podcast of two rabid anti-Scientologists and bigotry. Furthermore, if any of the opinions imply statement of fact, the opinions themselves disclose the basis and are thus not actionable, which is fair enough, true, too, right? If as long as you can't sue for, defamation by implication if, the thing makes clear what facts it's relying on. That's true. Yeah. Defendant's speech repeatedly identifies specific instances of hateful speech statements by plaintiff against the church, its leadership, and individual Scientologists. To cite examples, violence against Jehovah's Witnesses. After plaintiff aired an episode of The Aftermath attacking Jehovah's Witnesses, including commentary that religion was a cult, Stan posed the question whether violence relates to plaintiff's actions, citing the hateful content of the episode and spike of violence. Plaintiff is literally suing defendants for asking the question and explaining why they're asking the question. Fair. And it's a pretty common question. I think it's a bullshit question, but that's my opinion, right? I've already expressed my view on this, right? I take a somewhat reserved view on the concept of inspiring hate or inspiring someone to do something, right? I tend to look a little bit more towards incitement law, for example. Like, we need more than just like vague suggestions. We need something a little bit more before we're going to pull that trigger. I tend to take a pretty reserved view. People are responsible for their own actions. For the most part. So there are certainly exceptions. There's exceptions to everything. But so my default is, the Church of Scientology said some shit. And then some shit happened. I'm like, I don't care. And for the same reason, like Leia Remini said some shit and some shit happened. I don't care. I'm going to need more, Consistent standards, people. Consistent. Let's try to apply it both ways in fairness, Inspires praise of Hitler. The article, As the World Remembers the Holocaust, bigot Leia Remini inspires praise of Hitler. Concerns a tweet from plaintiff falsely accusing the church of stalking and harassing, with following replies by one of her followers. In the 1940s, there were certain European politicians who had big ideas. He had the right ideas, but went after the wrong groups. Scientology is a plague and needs to be exterminated. Well, that certainly does sound like it's invoking Hitler and calling for... It does kind of suggest... Yeah, something. The church's commentary on this exchange supposes the defamatory statement at issue is the Anti-Defamation League's pyramid of hate makes clear how hate speech, like Leia Remini's, advances to genocide against minority groups. Genocide like that called for by her supporter. An individual flamed by Leia Remini's unhinged propaganda and bigotry. An individual who is not surprisingly also a public supporter of Hitler. Well, I will chide the church or their lawyers at least a little slightly here, because they don't understand. They talk about hyperbole in their own, defense. Like, hyperbole is not a thing that you can sue over. But they read this statement flat. It's like, okay, our statements are hyperbolic, but this statement is real. So I'll chide them a little bit for the unequal application there. But nevertheless, they can read it flat. It can be read flat. I don't think it's fair to read it flat, but that's my opinion, right? You can read it like literally and say, well, they literally mean that. I mean, because they said that. So I wouldn't read it that way, but a person could read it that way. So, all right. As to rape apologists, as noted above, the plaintiff complains that editorial on Stand asked the question if she was a rape apologist, and the use of the hashtag Remini loves rapists, and a Photoshop parody of an image with her with the tattoo I heart rapists. The basis for the rape apologist opinion is revealed right in the article itself. Plaintiff's vocal public and continuing support for adjudicated rapist Paul Haggis and for disgraced accused sexual predator Les Moves. Even the parody tweets of I heart rapists and the hashtag Remini loves rapists reveal the basis for the opinion, showing tattoos of I heart Paul and I heart Les on plaintiff's arm. Any reader can see the grounds for defense conclusion that she supports rapists. Fair enough. Laura Lenny gifted 20 gift memberships. Thank you, Laura. Thank you, Laura, for the 20 gift memberships. That means that I can have some fish food now, or some beef food. Either one works, but either way, that means I get to eat for another day. Your super chat contributions are appreciated. Thank you. Okay. Abusive employer. Plaintiff complains that journalists, supposedly acting at the direction of defendants, interviewed persons about assertions that plaintiff engaged in abusive workplace conduct. Plaintiff does not identify any defamatory statement. A journalist asking questions while researching a story cannot by itself be defamation. It can be defamation, right? Because sometimes when you ask a question, you're not really asking a question, are you? Did you hear what I just said? Sometimes when you're asking a question, you're not really asking a question, are you? You get it? All right, moving on. In any event, there's a long trail of former employees and coworkers who assert plaintiff is abusive in the workplace, as documented on the website plaintiff complains about. Plaintiff told a former assistant, "You're doing a crappy job. You don't know what you're doing. You're a stupid person. Get out of my house. Get out of my life. Go away. Do whatever. Just don't do it around me right now because you're stupid and you're pregnant." Wow. Okay, that's all right. No comment on that one. Another former assistant had the temerity to respond fine in response to one of plaintiff's demand and suffered the consequences for not being sufficiently servile. And Leah tore into her. That's abuse. She berated me. She berated her, made her feel small, made her feel like shit, worthless. Like this is what? She pounded her into the ground for talking to her with attitude. Plaintiff's former manager quit rather than continuing to endure plaintiff's abuses and belittling behavior. And then I'd see her with other people, and it was the same way. Always putting people down, always treating them as if they weren't good enough for her. Okay, fair enough. I'm not going to work with someone like that. I couldn't work with someone like that who didn't appreciate others. I thought it was just me that she didn't appreciate. But then I saw her with others. It was truly evil the way she was talking to other people. Plaintiff's employees that complained about her abusive workplace behavior. It is more than fair interpretation of the disclosed and unchallenged facts to observe plaintiff as an abusive employer. Well, at least it's someone's opinion. I wouldn't go so hard as to call it a fact, but it is someone's opinion, which, fair enough. Can you see the bee fish, Miss Jax? I don't know. I mean, the bee fish typically only comes out for super chats, but if you super chat, I'll show you the bee fish, and I'll even do the voice. The bee fish is a perk. True statements are a complete defense to defamation. To establish the defense of truth, defendant need not prove literal truth of the alleged accusation so long as the imputation is substantially true. Yeah, not enough daylight. We've talked about that before. If there's not enough daylight between the supposed defamation and the pleaded truth, we don't care, right? If it's like, okay, it isn't literally true, but it's close enough, we don't care. Whoa. Plaintiff has the burden, furthermore, as plaintiff is a public figure, and certainly with respect to her relationship to the church, plaintiff has the burden of showing that she'll be able to produce clear and convincing evidence the speech was made with actual malice, knowledge statements was false, or with reckless disregard as to whether it's true. The statements are true and confirmed by either plaintiff herself or third parties, so there is no actual malice. Okay. Plaintiff's speech has inspired, resulted in acts of threats. I don't know what that means and also kind of don't care. But sure. Right, I would say like it's just an opinion at that point personally, but fine. Plaintiff is suing defendants for defamation for asserting that through her statements through the years has generated threats of an actual violence against the church and its members as evidenced by multiple convictions of individuals poisoned by her propaganda, including that a man incited by her hate speech murdered a 24-year-old Scientologist. The statements are true, at least a very fair opinion of events where defendant disclosed the supporting facts. Regarding the murder of Scientologists in Australia, the murderer used his cell phone to view an anti-Scientologist website that featured a link to plaintiff's television show. Defendants made the fact known that the television network airing plaintiff's show in correspondence to plaintiff herself cites the complaint, though the complaint omits the fact. Defendants show above other violent criminals inspired by plaintiff's hate speech against the church and incorporate that evidence here. This includes Brandon Risdorf, who attacked the Scientology in anticipation of plaintiff's appearance on 2020, threatened the leader of the Scientology religion, then was treated to a sympathetic interview by plaintiff on her television show, and after his star turn, was arrested again for violating a restraining order to protect the church. With complete accuracy, at Exposed Network, not one of defendants' accounts, tweeted that plaintiff brought a convicted felon who had vandalized the church's Scientology U.S. headquarters and threatened to murder one of its leaders onto her show to praise his criminal conduct. Yeah. Plaintiff now sues for defamation for this very tweet. Sure, the church has documented hundreds of threats to Scientology posted by her followers, which again, I don't hold Leia responsible for that because that's not fair. Again, the very correspondence that plaintiff relies on for her claims, but plaintiff disputes none of the evidence. Statements by plaintiff's family that she's a liar and stolen from them. Plaintiff asserts that defendant somehow, and the how is not described, manipulated her family into making statements about her. But plaintiff's father and stepmother did state that she is a liar, that she only wanted her name in the news, that she would not help pay for her father's cancer treatments, that she turned her back on her half-sister who was in the hospital, that she ransacked her dying grandmother's apartment, and she has no morals. Plaintiff concedes that her family made these accusations. She does not point to any of the statements that would alert defendant to their supposed falsity, referring instead to some secret document she has. Plaintiff's quarrel with defendants is not that they fabricated a quote, but that they never approached Miss Remini to seek comment or fact-check the false allegations her father made about her on camera. This is rich. Plaintiff boasted that she did no vetting of the guests on her television show and takes their word for it. Plaintiff crowed that legal at A&E had to accommodate her no vetting process. Undoubtedly, the legal department at A&E relied more on St. Aminet versus Thompson, which held that failure to fact-check a story does not establish actual malice. It certainly does not. No, it does not. Actual malice is only about what you know or recklessly disregard. Mere fact-checking is not enough, no. Plaintiff calling her daughter the C word and admitting that she trained her to beat other girls. Plaintiff alleges that an account operated by the church tweeted that plaintiff calls her daughter a C word all the time. The source for the statement is Julianne Williams, a former friend of plaintiff. She was constantly just like an antagonistic person, she called her daughter a C word all the time. Like I think that all the time, her 2, 3, 4-year-old, a little bitch. Plaintiff does not dispute the statement. As to the statement, plaintiff admitted that she trained her daughter to beat other girls. Any regular viewer of the Wendy Williams show could verify the statement. On broadcast television, plaintiff explained that when her daughter came to her about problems she was having with other girls, she advised her, beat the crap out of her. Don't pull back. Grab her hair right away. Hold your hands and punch the little bleep. The video shows the plaintiff demonstrating how to grab a little girl by the hair and repeatedly punch her in the face. This is a pretty thorough and devastating response, I think. I was already pretty inclined to rule against Leia anyway, to be honest. And this is further inclining me to rule against Leia. It's not looking great for her side on the way, to be honest. Plaintiff's hiring and payment of criminals and liars. Plaintiff complains that in 2018, defendants stated that other contributors to her television show were criminals or paid to appear on her show. The complaint does not quote the statements made or identify the speaker, and thus the claim fails for the reasons alone. But plaintiff look no further than Mike Rinder, the co-host and co-producer of the show. As shown in websites the complaint cites, Mr. Rinder is a perpetrator of domestic violence, as admitted under oath to being a serial liar. Other liars or under criminals recruited to be on the show include Valerie Henney, plaintiff's own personal assistant, who admitted she's a liar and made statements on the show about her Scientology experience that flat out contradicts statements she made praising the church. Brandon Resdorf, who was convicted of felony vandalism of a church facility. Zainaya Marsh, who once pled guilty to filing a false police report, was recruited by the plaintiff to be on the show with promises of a free car. Babette Rails, who was arrested in 2015 for domestic violence, for which he received a 1-year probation sentence. Paul Haggis, who a jury found to have committed rape and imposed a judgment of $10 million. A tipster told church legal counsel that the plaintiff told guests that they need to make their Scientology experiences as bad as possible, and that guests receive payments for their interviews. Morgan Branham was compensated by Remy's Corporation, the Aftermath Foundation, which bought a car for him for his appearance on the show. When Branham was in Los Angeles for his appearance on the show, plaintiff asked Aaron Smith Levin, a recruiter for the show, Hey Aaron, how you doing? Hey Aaron. What are we doing for him? Smith Levin said that Branham would be getting a new car, some college tuition, and a place to live. Branham was later offered $200 to return to Los Angeles for additional filming. Zainaya Marsh, one of the criminals mentioned, received financial assistance for her agreement to be on the show. They do spin the spin. Well, they're doing a pretty good job of it, Janine. I have to be honest. I mean, you know, maybe they are doing a good job of spinning the spin, but you know, this first of all, I was kind of skeptical in the first instance. I thought it was problematic for reasons I expressed previously, and maybe they are spinning the spin, but they're doing a good job at it. So, you know, all I can say to Leia's side is I hope that your reply to this is really good, because right now they're kind of kicking her ass. Advertisers have left plaintiff People Puzzler show. At paragraph 150, plaintiff screenshots a tweet from a stand that accurately states, another advertiser has canceled their ads on People Puzzler, the game show network program hosted by anti-religious bigot Leah Remini. This marks the 5th advertiser to cancel Remini. Plaintiff does not dispute the truth of the statement. Instead, she asserts that presents her in a false light because Stand also tweeted an image of plaintiff with logos of sponsors on her show, 21 logos to be precise. But Stan did not claim that those sponsors had canceled their ads. The tweet preceding the image expressly stated that 5 sponsors canceled their ad, not 21. I don't know about that one. Okay, that one isn't strong Scientology, but you know, if you're going to try to win on that alone, you're going to have a bad time. So, okay, I'll rule against you on that one, but I'm going to need a lot more to sustain this cause of action. Yeah, Aaron is here. Is Aaron actually in chat? That'd be cool. If he was actually here, that'd be awesome. It's like, yeah, I have summoned you, sir. I have summoned you. The B-Fish also summons you. What is the Church of Scientology's official position on the B-Fish? This is what I need to know in my life. Does the Church of Scientology support the B-Fish, Or do they think the bee fish is an abomination? This I need to know. All hail the bee fish. Maybe the bee fish can get some OT levels. That'd be good. Maybe the bee fish is already in Scientology. Are you in Scientology? I can't talk about it. Don't ask me about the truth. Okay. The same. All right. Defendants are not liable for statements by third parties. Plaintiff alleges without any factual support that defendants or individuals directed by defendants also have control over hundreds of Twitter handles. This supposedly made defendant for statements. The B-Fish is REOT9. That could be true. That statement is false. Many of the identified Twitter handles are neither church accounts nor controlled by the church. Defendant neither controls the handles nor individuals using the handles. For instance, the plaintiff singles out tweets by @ForensicFracker, but Forensic Fracker is not a church account. Any such claim of defamation against defendants while statements of third parties fails. Yeah, fair enough. They're not responsible for the same reasons we talked about, right? Yeah. All right. We'll skip actual malice because they're going to have a pretty hard time on actual malice. Plaintiffs cannot prevail. Yeah, because we can just kind of skip that because we already have problems. They're going to have problems with actual malice. So the Church of Scientology has issues there. Public figures like plaintiff may not recover for the tort of intentional infliction of emotional distress based on publication unless they show that the publication included a false statement of fact made with actual malice. Cause of actions expressly include claims based on the same instance to protect speech, thus must fail. Okay. The IID cause of action expressly relies on investigative context such as punitive surveillance. She might be able to keep the surveillance stuff alive, maybe. I think saying that it's pre-litigation conduct is kind of a stretch because it went on for so long. I don't think that quite works, but yeah. The claims based on investigatory conduct must fail because such permissible legal conduct cannot be extreme and outrageous. Yeah, so she might be able to keep that part of the lawsuit alive if she works on it. Finally, many of the putative claims for IID are barred by the 2-year statute of limitations. The following IID claims allegedly occurred before August 2nd, 2021, and are thus barred. Yeah. Can't prevail on civil harassment. Plaintiff's attempts to assert a cause for civil harassment under California Code of Civil Procedure and seeks compensatory and punitive damages. The cause of action fails on its face as there's no private right of action for monetary damages created by a Code of Civil Procedure. The statute only provides a mechanism for a party to obtain a temporary restraining order. Okay. Even if the court were to construe the civil cause of action as a petition under the section would still fail. A civil harassment petition for a temporary restraining order requires plaintiff to prove unlawful violence, a credible threat of violence, or knowing and willful course of conduct directed at a specific person that seriously alarms, annoys, or harasses the person, that serves no legitimate purpose, which would cause a reasonable person to suffer substantial emotional distress and actually cause the distress. Thank you, Lulu, for becoming a uncivilian. The bee fish appreciates your membership. Second, plaintiff identified several claims within her cause of action, including false and malicious accusations that were made against Miss Remedy and at times her family, as well as defamatory pattern of conduct. As the content at issue here is an arguably protected speech, it serves a legitimate purpose. Yeah, you're blending the issues of conduct with the speech, though, so you might be able to keep it alive for the surveillance, maybe, but you're still going to have problems because, as they point out, you're a public person, you're followed around by the public paparazzi, no reasonable expectation of privacy in public, and so forth and so on. So, yeah, you're going to have some problems. You know? The third cause of action also includes claims of following and surveilling, but the claims also include instances of protected conduct, such as pre-litigation investigation. That part's a little weak on the Church of Scientology's part. I think saying this is all pre-litigation conduct is kind of stretching it too far. It's like everything we've been doing since 2013 is pre-litigation conduct. I don't know about that, man. I don't know about that one. That seems too much. Cannot prevail in stalking. To show stalking, you must show the defendant engaged in a pattern of conduct, the intent of which was to follow, alarm, or harass the plaintiff. As a result of the pattern of conduct, plaintiff reasonably feels for their safety. The defendant either made a credible threat with the intent to place plaintiff in reasonable fear, or violated a restraining order. Plaintiff has the burden of showing the stalking claims based on protected activity that are legally and factually supported that they cannot do. Plaintiff relies on many individual claims, presuming both protected speech and protected pre-litigation investigation. Those claims fail because the conduct is legally non-actionable. Constitutionally protected activity cannot serve as a credible threat for purposes of stalking. You might be able to get somewhere on the surveillance, maybe, but yeah, she has problems. Furthermore, the First Amendment protects even speech the plaintiff may regard as threatening. The standard of actionable unprotected threat is where a defendant consciously disregards substantial risk that communications would be viewed as threatening violence. In 310 paragraphs of salacious and self-serving allegations, as opposed to what, I suppose, because that's sort of the nature of allegations. As Emily D. Baker says, complaints are allegations and shade. Of course they're self-serving. Plaintiff is not pointing to a single credible threat made against her. The failure of a key element also dooms the stalking clause. Okay. Tortious interference fails because it's all protected speech. To organize boycotts, we can skip that. Cannot declare on declaratory relief claim. Plaintiff seeks an order enjoining the church from future expressions of free speech and petitioning, and most astonishingly, to alter actual and alleged church scripture. Specifically, she asked the court for a judicial declaration the practice of suppressive purpose operations are unlawful and should cease immediately. Her prayer for relief is more straightforward, where she asked for injunctive relief, requiring the Church of Scientology cease and desist, harassment, defamation, and other unlawful conduct, and striking all suppressive person and fair game policies. No artful phrasing can hide what she seeks from the court. She's asking for unconstitutional power restraint on defendant speech and petitioning activities, and beyond precedent, for this court to modify, if not erase, certain church doctrine and alleged scripture. Yeah, I mean, she has a point. They can order them to stop doing specific acts, but they can't modify their internal policies like that. And I don't think that's going to go any further. That's going to work. They're entitled to fees and costs, maybe. And so for those reasons, they should grant the motion. Yeah, okay. So I think the Church of Scientology is definitely on the upswing, but I thought they were already on the upswing before. So I think that, yeah, the Church of Scientology has a point, and we've already identified some of these defects. Some of the statements are opinion. Some of the statements are hyperbolic. Some of the statements are just a way to interpret the facts in light of, various things that have been said by various people. So I think that that's all sort of, okay. Let me see if I can fix the lighting a little bit while I'm here. Let's see. Let's see if I can fix the color. Let's see. That's the wrong way to go. Let's see if I can, that's too much. Let's see. Dun, 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 dun. All right. 4,200, 4,600, 4,200. Come on. 4,400 is too much. 4,400, 4,100, 4,200, 4,300, 4,200. We'll try 4,200. All right. We'll try that. I don't know why my face seems so red right now. All right, let's see if we can end on a fun story. What else do we have in the queue that we can end with? Softset who created their own vehicle plate. It's just a video. So we'll skip that. But yeah, some of the Softsets try some stuff with the plates. How about this one? Florida man with all gas, no brakes, neck tattoo, crashes after fleeing the police. Florida man will always come to the rescue. Florida man will always come to the rescue. Florida man has been arrested and a woman remains hospitalized after deputies said the couple was involved in a vehicle crash as they tried to flee from authorities following reports of car burglaries. According to the sheriff's office, deputies responded to the burglaries in the neighborhood around 3:20 in the morning. Deputies say the man and woman were seen trying to break into several vehicles in the neighborhood. That seems like a clue. According to the police, the suspect's white 2006 Cadillac was last seen headed towards the only exit out of the neighborhood. A deputy said he tried to pull the Cadillac over, but it sped away. The police say the deputy did not pursue the car because there's only one way in and one way out of the subdivision. They were like a trapped mouse running around trying to get out of there. While speeding, oh my God, look at this guy. Holy shit. Put him in prison. Put him in for prison forever, dude. Shit. According to the police, the Cadillac eventually slammed into a parked and unoccupied vehicle. If they're going to lose control, they could slam into a house and people could get hurt. Well, someone did get hurt. It was the burglars. Deputies say they immediately pulled two suspects out of the disabled Cadillac and called for emergency medical. According to the police, Timothy Allen Hogue, 37, was driving the Cadillac when it crashed, and 31-year-old Rebecca Kozub of Okokie was in the passenger seat. This guy looks like he's a threat to me and everyone I've ever loved. Damn. Detectives who interviewed Hogue after he was released from the hospital say he admitted to the burglary and the crime was Kozub's idea. According to deputies, Hogue said that he fled just because he freaked out. Hogue, who has prior criminal history that consists of 31 felonies. How is this guy out? How is this guy out? Someone's got to explain some of these things to me. He has 31 felonies? How's he walking the streets? "31 felonies and 18 misdemeanors. Now faces charges of burglary of an unoccupied conveyance with enhancement of crossing county lines, felony petty theft, fleeing to elude, conspiracy to commit burglary, possession of methamphetamine, possession of marijuana, possession of drug paraphernalia, and resistance without violence." And he set a bond of $11,500. The passenger, for her part, has 19 felonies and 20 misdemeanors. Whatever happened to 3 strikes and you're out, man? Damn. That's depressing, man. Concurrent time, yeah, put him in jail forever, man. Put him in jail forever. Holy shit. Put them both in jail forever. 19 felonies and 20 misdemeanors? Uncivil Law has a total of 0 felonies and 0 misdemeanors, I'd like to tell you. Petty honest throwaway rather, gives $9.99. Thank you very much, Petty honest throwaway, for the $9.99 super chat. B appreciates it. Yay! Since we're about to end, I have a question based off a video I watched. Can you sue someone for posting a TikTok or a video of you for using image without your consent for profits off the video? Well, it depends. Like all good things. So, first off, well, like, okay, we'll assume they took the video, because if you took the video, obviously you have a copyright claim. So we'll assume that they took the video. Okay, did they take the video of you in a public place? If so, then probably it's fine, because no reasonable expectation of privacy. Unless they're using the footage to sell something, then there's no like association. So like if they were trying to use the image to sell a product, then maybe, but answer is probably no. Answer's probably no. So, you know, if they took the images in some place where, you know, you weren't expecting privacy and you're out in public and they're just posting it, and, you know, then yeah, probably. Yeah. So based on yeah, I'm talking about people filming other people in public and posting it for purposes of ridicule. Yeah, then probably not. You probably can't sue for that. There's probably no cause of action in that. If they are taking images of you and you're in public and they're just making opinions like, you know, look at this guy, then no, there's probably no cause of action in that. Probably not. The judicial system isn't fair. The guy who killed my uncle is out only after 5 years in jail. He had premeditation for the murder and torture was involved. So unfair. See, I don't understand how that's possible. I'm not really sure that's the justice system. I'm not sure what that is. Like, that doesn't make any sense to me. How is that possible? So I don't know how some of these people just keep getting out over and over again. I don't get it, you know? I don't get it. All right, this one is a little bit more fun. Okay, we'll try this one to see if this one's funner. More fun. All right. A serial wedding crasher who steals wedding gifts at the weddings he crashes. Oh, she crashes. Sorry. Sandra, not Armand, hopefully. Sandra Lynn Henson, 57, allegedly hit 5 weddings in Alabama in a single day. The serial wedding crashers targeted weddings in 3 states, stealing tens of thousands of dollars in cashes and gift cards. Is free again after her last hike. Mississippi resident Sandra, who is 57, has pulled off the thefts by creeping from table to table, snatching cash and credit cards from people's purses, and raiding gift tables. Don't do that, man. Don't do that. That's not good. Miss Henderson has been arrested in Alabama, Tennessee, and Mississippi for crashing weddings and stealing money from cards and purses. She was most recently busted in September at Lexi and Brady Butler's wedding in Lily Creek Farm in Belden, Mississippi, after members of the bridal party noticed her alone in the bridal room. Pictured here is a woman named Sandy, who Sandy in her chat says is unrelated to her. So, okay. The bride and groom were outside with most guests when the bride's sister and wedding planner spotted Henson. She had a plate with some cake in her hand and was slowly eating it. The sister quizzed her on who accompanied her to the wedding. She gave some random name and said the person already left. That was when the wedding planner remembered the guest was missing a makeup bag and went to the person and noticed that she was missing cash. They confronted her, and she confessed producing $200 from her bra. She is currently on probation after a prison stint for similar crimes, pleaded guilty to petite larceny, trespassing, and disturbing the peace. She's ordered to pay $650 fine and released on probation. I can't pronounce the state name. It's that late. Texas Katie did. Hello, Texas Katie did. Thank you for the $10 super chat. I appreciate it. Okay. In 1972, Scientology framed Paulette Cooper by sending itself bomb threats on paper stolen from her home. FBI proved that in 1977. They also made a webpage exposing each of their critics. I'm not here to say that Scientology, let me rephrase. I'm not here to say that Scientology, either globally or any of its members individually, are necessarily a bastion of peace and light and greatness in the world. B-Fish may or may not be a member of Scientology. We're not sure. Uncivil Law is not a member of Scientology and has never been a member of Scientology and is not particularly inclined to join Scientology. Doesn't seem like the faith for him. Also, some of the things, but you know, I'm aware of science. I'm aware, at least on a global level, of some of Scientology's sins over the years. I'm aware of Operation Snow White, for example. I'm aware of some of the other things that Scientology has been involved in. That being the case, of course, as a good legal analysis channel, I would do a disservice to you if I brought that knowledge in this specific case with Leah Remini, right? Every case has to be judged unto its own merits. This was what I was trying to tell the non-lawyer who I recently had a confrontation with on Nick's stream, but was unable to get the point out because feelings and, you know, hospital's bad, hospital's real bad. It's like, you know, it's like, look, what we have to do when we're doing the law game thing is we have to approach this on a person by person and cause of action by cause of action analysis. We have to look at it with respect to the particular issue at hand and adjudicate it in a fair way with respect to each particular issue. So if you're trying to tell me that Scientology or members of Scientology have done some bad stuff in the past, I'm certainly happy to concede the point. I just don't know how much I I just can't really use that information as it relates to Leia's particular case. I have to adjudicate it on its own merits, like a good lawyer or a good judge. So that's, you know, and then we try to assess things and try to assess reasonable things. Yeah. So, you know, just trying to assess things fairly. I think also to some degree, and I'm not sure whether it was me expressing the point fairly or people misunderstanding it, but I think to some degree also when I was critiquing the verdict, I think people misunderstood at least partially that I was like showing potential problems and like, you know, I'm not sure if this number works or I'm not sure if this number works. I'm like, you know, just I'm raising questions and I'm also like, you know, I'm not sure this cause of action works. You know, I'm not sure this quite works. And, you know, I have some issues here and some problems here. And, you know, some of the stuff is, and some of these numbers seem a little high to me. You know, it's just and it's also very back of the envelope analysis, you know. So who knows what the Court of Appeals someday will do. But I think people misunderstood my critique of the verdict as somehow suggesting that bad things didn't happen to Maya and her mother. Whether the hospital is responsible for those things is, of course, where the legal analysis comes from, and we have to look at it in a logical, reasoned way. And the med mal case, the med negligence may survive. It may well survive. People have pointed to some ideas that could work. So it could work. The cause of death for Maya's mother is basically just a pure issue of law, though. And so that's just a pure legal question. Who knows what's going to happen? And that's where all the real damages are, right? That's where like $100 million of the damages are. So if Johns Hopkins can get that wiped out, then they'll be a lot happier. They'll be half as well off. So, you know. Nick's Abias's model release forms are there for a reason. That's true, but those are also in different contexts. And, you know, and also a CYA move. Like, even if it's like consent from the police, you know? If I were a police officer, even if I could get a warrant, I'd always ask for permission, right? Do you mind if I search your car? Do you mind if I search your house? Because if you say yes, that solves my problem right up, right? So like, and I may not need permission, right? But if I can get it, it's a nice to have, right? Like, can I search your house? No. Okay, I'm coming in and I'm searching anyway, right? It's like, you know, consent's a nice to have. So is a signed model release required? Sometimes it might be. Sometimes it might not be. Sometimes it's just a nice to have. It's a nice to have. It's an additional little bit of insurance that I can put in my pocket and makes me feel all warm and fuzzy inside, you know? It's like, oh, you know, I don't necessarily need this, but I have it, and it makes me feel safe and happy. So yeah, signed photography releases are certainly a thing. Are they always required? Probably not. Would I like to have one? Would I, as your lawyer, advise you, you know, you should get it if you can? Of course I would, because it solves a problem, right? It's just one more thing that I have to make your life easier. I'm here to protect you, my client, right? So it's like, do you need it? No, strictly speaking, probably not. But why not get it anyway? It costs you nothing. It makes my life easier. So yeah. So yeah. And incidentally, by the way, just for the sake of pointing things out, just in case anyone cared, uh, people have commented on the stream, including, incidentally, Andrew from Legal Mindset was the name of the channel I was looking for. Shit, that took me longer than I should have. Andrew from Legal Mindset recently commented on the video, and Nick Rakita recently had a discussion about the video with Steve Gosney, and I saw their comments, and yeah, that's fine. I like all these people. So if you're looking for drama between me and Nick or me and Andrew, you've come very much to the wrong person. They're entitled to their opinions and their views. I actually respect them. So, you know, I thought their critiques were fair, even if I didn't necessarily personally agree with it. I'm not necessarily required to agree with it, but I thought their critiques were fair and in the spirit of, for lack of a better word, friendship. I didn't think they were going out of their way to, like, you know, burn a bridge or anything. So I took their comments with, you know, with charity, and then, you know, it's fine. I don't care. So I don't care. Their comments are fine. They're more than happy to have an opinion. It's fine. So just in case someone was wondering if there's beef, there's not, at least as far as I'm concerned. There's no beef between me and Andrew of Legal Mindset. There's no beef between me and Nick. We're all still 100% good. It's fine. I thought Nick's comments were interesting and fair. At least it's like, you know, no lawyer is great at everything, and me, Uncivil, is better at some things than not others, and maybe I'm not the guy to make the argument to the jury. Maybe. I'm much more interested in appellate law than trial work, so, you know, possibly that's a fair critique, right? Maybe I'm not the first pick. Like, if you had to pick between LawTube, like, who do you want making the argument to the jury? I think you could very reasonably say that, you know, me would not be your first choice. I think it's a very reasonable thing. So I understand that. It's all good. EDB and I are cool as far as I'm concerned. I don't really have any problems with anybody who's within LawTube. Any problems I had with anyone, I let go long ago. Do I have Southern Febreze? I do have Southern Febreze. Yeah, I got some Southern Febreze. All right, I'm going to sign off, guys. It's been a long stream, and I've had fun. It's been an interesting day. A lot of tech problems today. A lot of tech problems today. It's just one of those days where a lot of little minor things went wrong. You got a light bulb on its way out. Couldn't find the right remote for my iPhone. Picked up a remote, and it didn't work for my phone. Had to buy another one. Now my third attempt to buy a thing. Tried an app to record something. It's supposed to be voice recognized transcriber. Didn't really work. TV broke. My scale, my nice scale isn't working properly. I have to buy another one of those. Had the microphone issues recently. But B-Fish is here. B-Fish is here. Let's watch B-Fish again. Thank you, Tony, by the way, for creating B-Fish. It was nice. Tomorrow is a new day. That's true. Tomorrow is a new day. Yeah. I'm happy to be home. I'm happy to be home. Did I cut my finger? Yeah, I got some stuff on my finger, but I'll be fine. All right, I'm going to sign off for now. It's been fun. I hope all's well. I will see you later. Have a good one. Bye-bye.